Hi, I'm Deb Diesing, and I'm going to describe to you the process for filing for an arbitration. Arbitration comes under Article 17 of the Code of Ethics, and it's available for brokers who most often find themselves in procuring cause disputes, although other disputes can also be handled in arbitration. The process is only available to brokers under Article 17, and a broker who is requesting arbitration must file that request on the proper form available on the association's website. A couple of details are, it must be filed within 180 days of the closing or the payment to the respondent broker, and it must not be too large or too small an amount of money or already have pending legal action filed in the same dispute. After the request for arbitration is filed, our association applies mandatory mediation to the parties. What this means is the brokers must meet with a trained mediator, and the mediator's job is not to decide the outcome of the dispute, but to get the two parties, the brokers, to come to their own conclusion by using mediation tactics and training in order to facilitate this agreement between the brokers. If the brokers come to their own agreement, they put it in writing and they are bound by that decision. If they are unsuccessful, the next step is for an arbitration to occur. The arbitration process happens much like an ethics process, except that no ethics violations are brought up in an arbitration hearing. The only item to be discussed is the procuring cause or other entitlement to the money that is in dispute. The hearing process begins by the panelists, the broker who is the complainant, and the broker who is the respondent, and any witnesses that they bring or any counsel, realtor counsel or attorney that they wish to bring, entering the hearing. People who will be giving testimony will be sworn in, and the case opens with the complainant stating their case. Once they have finished that, the respondent can cross-examine them, and the panelists are allowed to ask questions of the complainant as well. Then, one at a time, witnesses are brought into the room who can be examined by the complainant, cross-examined by the respondent, and asked questions by the panelists if they have any. Then it shifts to the respondent side, and the respondent can state their case, they can call witnesses, the complainant gets to cross-examine the respondent and their witnesses, and the panelists get to ask any questions of the respondent. At the end of the hearing, they each make a closing statement, and then they are dismissed from the room. At that time, the panelists will deliberate, and they are looking for a preponderance of evidence as the standard, meaning if you were to look at a scale, that the scale was tipped just a little bit more with evidence toward one party than the other. So some people call that the 51% rule, meaning whichever party has 51% of the evidence in their favor will win the arbitration. The panelists will decide who the prevailing party is. In the case of an arbitration, arbitrations are all or nothing. The party who tipped that scale just a little bit more will be deemed the winner and awarded the amount of money. Remember, in a mediation, the parties are free to split the money however they choose. In an arbitration, there is one winner and one loser.